10 seconds to go. A perusal of the order dated 16-10-1993 would clearly indicate that the employment of the petitioner as a lecturer in humanities and social sciences under the Regional Engineering College is a re-employment and not a regular employment. Rule 7(2) of the CCS Pension Rules 1960 provides that a government servant who, having retired on a superannuation pension or retiring pension, is subsequently re-employed shall not be entitled to a separate pension or gratuity for the period of his re-employment. The case of the petitioner was that she joined as assistant teacher in the government high school Kohima, Nagaland on October 3, 1967. While she was serving as such, the petitioner applied through proper channel in response to an advertisement issued by the erstwhile Regional Engineering College. The petitioner was elected by the Regional Engineering College and she joined as lecturer in the Department on Humanities and Social Sciences on April 6, 1984. While she was serving as lecturer in the REC, the petitioner was on leave under the state of Nagaland. In the meantime, petitioner applied for voluntary retirement from her service as assistant teacher, completion of 20 years service which was granted by the government of Nagaland. While granting the voluntary retirement, the government of Nagaland calculated the period of 3 years, 4 months, and 25 days rendered by the petitioner at REC for completing the said period of 20 years service to enable her to go on voluntary retirement. After availing voluntary retirement, the government of Nagaland paid monthly pension to the petitioner, which is continuing till today. The REC was converted to the National Institute of Technology on June 28, 2002. The NIT deducted the amount of pension received by the petitioner from her monthly salaries till her retirement on December 31, 2004. The petitioner was aggrieved by the communication dated November 14, 2014 written by the Assistant Registrar NIT and addressed to the petitioner, wherein it was stated that as the petitioner was granted the benefit of voluntary retirement by the government of Nagaland and subsequently re-employed in the college, petitioner is not entitled to get second pension from the institute in terms of Rule 7(2) of the CCS Pension Rules 1972. It was the case of the petitioner that as her pension amount was deducted from her salary by the NIT till her date of retirement, she is entitled to get pensionary benefits from the NIT. It was further argued that the petitioner was not under re-employment in the service of the NIT and therefore Rule 7(2) of the CCS Pension Rules 1972 is not applicable to her and therefore she is entitled to get pensionary benefits from the NIT, particularly when her pension amount from the government of Nagaland was deducted from her monthly salary till her retirement on December 31, 2004. The counsel for the respondents argued that the principal of the college, by an order dated October 16, 1993, had treated the service of the petitioner as re-employed pensioner with effect from April 1, 1988 under the REC. It was contended that the said order dated October 16, 1993 is not under challenge and the petitioner had accepted the said order and therefore petitioner cannot claim that her employment in the college